Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third party books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Dooher v. Williams, 6-9, Misc, 3D, 662, New York Supreme Court, Onondaga, 2020. Friends, we're going to talk about a case that may or may not be like other cases, and whether it's like or not like other cases, we need to discuss it because we're here to advance ballot access for third parties. This case involves a gentleman named Stephen Williams of the Working Families Party, a party we've been discussing a lot on this podcast lately. They are very big on litigation for these ballot access cases, so we applaud them for that. This case has a lot of big words, a lot of big legal words. And it introduces me to the New York electoral system. So let's read from the record to see what happened. It says, quote, on August 10, 2020, the 11th Judicial District Convention of the Working Families Party filed a certificate of nomination that purported to nominate Respondent Williams and 7 others as the party's candidates for the public office of the Justice of the Supreme Court in the 2020 general election. The Working Families Party had previously designated Williams as a candidate for Congress in the 24th Congressional District. Williams accepted the judicial nomination and on August 12th filed a certificate declining the congressional designation. In response to the purported vacancy created by Williams' declination, the State Executive Board of the Working Families Party filed a certificate of substitution designating Dana Ballot as the party's candidate in the 24th Congressional District. Petitioners collectively challenged the certificates of nomination, declination, and substitution in this and a related proceeding, asserting that the underlying judicial nominating convention was not lawfully constituted and therefore any action taken by the convention delegates in support of Williams as a candidate for the judicial office is a nullity. Petitioners further argue that since Williams' judicial nomination is without effect, his declination of the congressional designation is invalid and no vacancy was created in the 24th Congressional District for which a substitution could be made. End quote. Maybe that confuses you. Let's, as they say, unpack this. First, our friend here, Williams, was running under as a office of the Judicial Justice of the Supreme Court. Does your party have people eligible? Usually you have to be a lawyer to be a justice to run. Hope so. It'd be awesome to have your party represented as in a judicial position. Also, what happened here before he was a congressional nomination, and then because he accepted the judicial nomination, that opened it up, and this Dana Ballot, Dana can be a both male or female name, so I'm not sure if Dana is a male or female. Dana Ballot, whether male or female, then became the congressional candidate. Now, would you ever switch in the middle of an election from one office to the next? Maybe in the preliminary stages, a lot of people probably try to figure out which is the best office for them to run for. How about after you already got the nomination? This case, like I said earlier, involves a lot of big judicial words that I'm not going to repeat to you. And then they talk about the New York electoral system. For those of you from New York, kindly enlighten me about how this works. They talk about judicial districts and proportional representation. Then they have this big chart about all these assembly districts and how they need to be equal in each of those districts on the call for that convention to be valid. It seems confusing. I wonder how people from New York understand this, if it makes sense to them. So what do they decide? It says, quote, Accordingly, after due deliberation, it is hereby ordered that the petition is granted as ordered below. It is further ordered and adjudged that respondent New York City Board of Elections remove respondent Stephen Williams from the November 3rd, 2020 ballot as a working families candidate for the public office of the Justice of the Supreme Court, 11th Judicial District. It is further ordered and declared that respondent Stephen Williams' certificate of declination as a working families party candidate for the public office of the member of Congress, 24th Congressional District is void and of no legal effect. It is further ordered and adjudged that respondent New York State Board of Elections restore and name respondent Stephen Williams to the November 3rd, 2020 ballot as a working families party candidate for the public office of the member of Congress, 24th Congressional District. End quote. So is this a victory? It's not a victory in the sense that our friends at the Working Family Party and Mr. Stephen Williams did not get what they want. They wanted him to be listed as the judicial candidate. But the court here said that was not valid. They did, however, let him continue to be represented as the congressional candidate on the ballot. So it's good to be on the ballot. It's better to be on the ballot for something than for nothing, I suppose. I don't know how Stephen Williams liked that. I don't know how he could have viewed that. That's not what he wanted. So it's short of a victory. Maybe we could say it's a consolation prize. The Working Families Party does advance its cause by being on the ballot, even if it's not in the way it wanted, and not in the way it believed it deserved under law. So friends, let us consider this verdict and think about how we shall continue to advance third parties and ballot access for third parties. Long live third parties. Goodbye.